5 seconds to go. Start. Furthermore, the respondent number 1 has contended that no departmental inquiry was ever initiated against him in relation to the registration of case crime number 967 of 2007. However, the trial court in its order dated 10th July 2015 has made an observation that the respondent numbers 1, 3, 4 and 5 respectively were suspended and also subjected to an inquiry. Whether the departmental inquiry was initiated against all the accused respondents or just some of them, and the exact findings of the inquiry is also an aspect where there exists some ambiguity. Having said so, on the other hand, the respondent numbers 3, 4, and 5 respectively have also not adduced any credible evidence before us to prima facie establish that it was Ashok Dikshit who was arrested at 9:30 am at Murad, Gwalior, that the illegal liquor carried by him was seized, and that he was later released from the Murad police station on the directions of SHO D.S. Kushwaha upon furnishing a surety. It is true that the offence contemplated under Section 34 of the Excise Act is bailable, and that any accused under the said offence would be entitled to be released on bail from the police station. However, bearing in mind that there exists serious suspicion as to whether an arrest was ever made to begin with, and if made, whether it was Ashok Dikshit who was indeed arrested, we find ourselves unable to arrive at an appropriate decision at this stage due to lack of reliable and credible evidence to verify the same. The respondent numbers 3, 4 and 5 respectively have stated that the accused had identified himself to be Ashok Dikshit upon arrest, and it is unclear whether the identity of the said accused was further duly verified while the case was registered under the Excise Act. Despite the appellant's allegation that the release of the said accused on bail from the police station was done hurriedly, almost immediately after arrest, in order to conceal the identity of the person who was released, and that an unconnected stranger might have been released from the police station, no other material which substantiates the bona fides of respondent numbers 3, 4 and 5 have been made available before us at the present moment. It is the case of the IO at Dakshin Firozabad that sanction for prosecution of the accused respondents was not granted by the DIG Gwalior, citing the pendency of case number 15003 of 2007 in case crime number 967 of 2007 registered for the offence under the Excise Act before the CJM Gwalior. However, those proceedings have been stayed by the High Court of Madhya Pradesh by order dated 25th August 2009, and therefore the question of sanction can be revisited if found necessary. As far as respondent number 1 is concerned, it is made clear that there would be no requirement for sanction since he was not acting in the discharge of his official duty by virtue of not being posted at Murad police station Gwalior at the relevant time when the alleged false case was registered. As a consequence, the extent of the involvement of respondent number 1 in the alleged conspiracy to murder can be determined by the trial court upon a further examination of the evidence adduced before itself. However, so far as the respondent numbers 3, 4 and 5 respectively are concerned, if the case of the prosecution that they had also played a dubious role in registering a false case is correct, then the requirement of sanction would not be a sine qua non for proceeding further with the criminal proceedings. However, the defense must be given an opportunity to rebut the same by leading appropriate evidence. At this juncture, on a prima facie examination of the materials adduced before us, we are of the opinion that the criminal proceedings pending before the CJM Firozabad as case numbers 67 of 2008 and 67A of 2009 should not have been quashed at such a preliminary stage. In cases where there is a legitimate doubt as regards whether sanction for prosecution under section 197 CRPC is required or not, the progress of the trial must not be hampered or unnecessarily delayed. Therefore, the CJM Firozabad had rightly taken cognizance of the two charge sheets, vide its orders dated 24th November 2008 and 10th August 2009 respectively. The High Court committed an error in failing to consider this aspect while quashing the proceedings in case number 67 of 2008 and 67A of 2009 respectively, vide its impugned order. In view of the aforesaid discussion, the trial court is directed to proceed with the trial and at any stage of the trial, if the evidence suggests that the acts complained of were indeed done or purported to be done in the discharge of official duty by respondent numbers 3, 4 and 5 respectively, or that the FIR registered by them was not bogus, the trial may be stayed for want of sanction. Therefore, the question of sanction only qua respondent numbers 3, 4 and 5 respectively is left open to be appropriately decided by the trial court at a suitable stage in accordance with the law without being prejudiced by any of the observations made in this order as well as in the order passed by the High Court. As these proceedings arise from a case registered more than 16 years ago, the trial court is directed to proceed with the trial and conclude it expeditiously, preferably within 1 year from today. In light of the aforesaid, the appeals filed by the appellant are allowed and the impugned order passed by the High Court is set aside. We dispose of the present appeals in light of the aforesaid directions. Pending application, if any, shall stand disposed of. Stop.